Good afternoon, and welcome to the Board of Health meeting of March 20th, 2023. This meeting is being recorded and will be available shortly hereafter for scheduled and on-demand viewing on any smartphone or tablet device. If anyone else is recording this meeting, please notify the chairman pursuant to Governor Baker's July 16th, 2022 signing of an act relative to extending certain COVID-19 measures adopted during the state of emergency, including the extension of the March 12th, 2020 and July 15th, 2022 orders suspending certain provisions of the open meeting law, general law, chapter 30A, section 20 until March 31st, 2023. This meeting of the Chatham Board of Health is being conducted in person and via remote participation. Every effort will be made to ensure that the public can adequately access the proceedings as provided for in the order. A reminder that persons who would like to listen to this meeting while in progress may do so by calling 508-945-4410, and the conference ID number is 599-754-886#, or join the meeting online via Microsoft Teams through the link in the posted agenda. While this is a live broadcast and simulcast on Channel 18, despite our best efforts, we may not be able to provide for real-time access. We will post a record of this meeting on the town's website as soon as possible. Now I'll turn the meeting over to Chairman Dr. Noble Hanson.
It shall be the policy of this board to conduct its meetings under the open meetings law so as to encourage public participation whenever time permits and as part of agenda item discussions. So today we have five items on the agenda, and first we'll get a quorum and say here, when I call your name, Dick Edwards.
Here.
Ron Berlman.
Here.
John Beckley.
Here.
Carol Boyce.
Here.
And Noble Hanson, I'm here. Okay, and Ed Sheehan has just come in as an alternate. Okay. First, we have a variance request for a real estate transfer regulation for Damon Wertinen, 739 Kroll Road. And I think Attorney Riley is going to present the case today. This is 739 Kroll Road.
I was just reminiscing with Ed because, you know, I remember when he was first appointed to the Board of Health. Bill Riley, I apologize for my casual attire. My partner, Jamie Norcross, is positive for COVID, so he's
Oh, boy.
at home, taking care of himself. So he asked me to cover for him. So this is a property that is currently owned by Jackson Smith, who requested the same thing. The property's currently uninhabitable, and the water's been turned off, so a waiver was granted to him when he purchased it. He's decided to sell it. Jamie's representing the purchaser. We believe that the property's going to be, the building's probably going to be demolished and a new building built. Although I don't think all the final decisions have been made about that yet. But in any event, they would like a variance to waive the requirement of the Title V inspection for a real estate transfer at this time.
Okay. And as I understand it, you have already agreed that the property remains vacant and that when you rebuild or remodel that the septic system will be inspected at that time, and that the water service is to remain disconnected?
That's correct. And the current septic system is cesspool, so
Everything's going to be brand new.
it's going to be brand new anyway.
Yeah.
But yes, we agree to those conditions.
Okay. Questions from the board? So this is just a renewal of the same kind of variance that was given a year ago with a new owner, another transfer.
That's correct.
But it's uninhabited and the water's turned off, so.
And I'm personally happy to see the lot has been cleaned up. At least if it's going to sit there a while. It looks much better now than it did.
Well, I think that's it. They say thank you to Jackson Smith. He's the one who took care of that.
Right.
Finally, I mean, it looked like a junkyard there for so many years.
Exactly.
So it's really
It's much more stable now, the way it
Yeah.
is.
Any other questions or comments? Can I get a motion?
Make a motion to approve it.
A motion to approve in a second?
Second,
And then I think we can take any comments from the public? All right, hearing none. Judy will read the conditions. Are these formal conditions? I think so.
They're the same, they're the same as before. The property will remain vacant until such time as the dwelling is renovated or rebuilt. The existing septic system is inspected or a new system is designed, approved, and installed, and water services to remain disconnected.
Right.
Okay, I think we can take a voice vote. All in favor, say aye.
Aye.
And all opposed, say no. All right. it
Thank you very
passes.
much. I appreciate your time.
Thank you very much. Okay, next is a variance hearing and approval for IA Technology for Sherborne Development Group, 51 Cove Hill Road, Ryder and Wilcox, the engineers. And can we have
Stephanie Sequin.
Stephanie
Yes.
Sequin? Yeah.
Yes, hi, good afternoon. Stephanie Sequin with Ryder and Wilcox. And I am representing Sherborne Development Group, who is recently purchased the property at 51 Cove Hill Road. It's a 47,536 square foot lot, all of it upland. There's currently a three-bedroom house on the property, and the septic system is a converted cesspool system. What's being proposed is to demolish that existing building and construct a new four-bedroom home, along with a pool and pool house, and there will be one bedroom in the pool house for a total of 5 bedrooms. So since we have only 47,500 square feet, just under the 50,000 square feet required for 5 bedrooms, as part of the septic system upgrade, we are including an Advantex wastewater treatment system, which is a DEP-approved technology for nitrogen reduction. It's been approved for reducing total nitrogen to from 35 to 19 milligrams per liter. So we've done soil testing, the soil's great. This will require, the way the site is being developed, it will require a pump system just because of the house being constructed at the low part of the lot. But there are, other than the variance from your nutrient management regulations, we don't need any other variances from Title V or Board of Health regulations. So I think it's pretty straightforward, and I'd be happy to answer any questions.
Okay, any questions or comments from the board?
A comment that the floor plan is a little unusual, but I don't see that there's any issue with it. The dining room is like 50 feet from the kitchen. But it looks like it's got a stairs up to the great room and open doorways, so it's not really to be confused with a bedroom, I guess. But it's a strange layout.
Yeah, I had, so on the first floor, we have that rule about arches now. What's the arch width going from the foyer into the dining room? That would make it not a bedroom?
Should be 6 feet.
I think we had changed it a few months ago to make it 6 feet. This
Okay,
looks like
but
it's
aren't
probably,
dining rooms exempt from?
the main, first floor, from the foyer to the dining room, there is an archway there that looks like it's probably 5 feet.
They're not, any room, they're not exempt. I mean, you're labeling it a dining room, but it could be easily a study or anything else. But that, I couldn't tell what the size of that cased opening was. So, but it should be 6 feet at minimum.
Okay,
Yeah, there's 2 entries into the dining room, it looks. There's one from the foyer and one from the great room. The great room, I guess, has steps going up to it, I don't know what that is.
I think that's some kind of a closet or something, or, yeah.
Oh, wait a minute. No, oh, no,
there's
no,
only
no. There
one.
is no entrance from the great room and the dining room. The only entrance to the dining room is from the foyer, right, and that doesn't look like it's 6 feet.
Right.
Yeah, they would have to remove the rest of that wall.
The other archway that I think would come into question is in the basement plan, from the recreation room to the lounge has also an archway, which is probably 5 feet. The newer rule is 6 feet, just to,
Okay, so,
it looks like both of them could be, I don't know, I'm not an expert, but it looks like there's room to widen both the arches pretty easily.
Cased
okay.
openings, yeah.
So I'm reading from your definition for bedroom, and it begins with, have criteria of having more than 70 square feet. Then it goes on to say living rooms, dining rooms, kitchens, halls, bathrooms, and unfinished cellars are not considered bedrooms. So a dining room, according to your definition, is not considered a bedroom, regardless of the size of the
But
opening.
it's not a dining room just because it says dining room on the plan.
Right.
If it's got privacy and enough space, it's a bedroom. It's it can be considered a bedroom. And-
Okay.
And in particular, in this case, where it's half a mile from the kitchen.
Well, formal dining room is
They're not-
generally set off,
Well,
to have it more quiet. So
Regardless,
what I would also like to present is your regulations go on to say, which I knew you might have questions, concerns about these rooms, where the total number of rooms for single-family dwellings exceeds 8, the number of bedrooms presumed shall be calculated by dividing the total number of rooms by 2, then rounding down to the next lowest whole number. So I've come up with 11 rooms
But that's
between the two buildings. And if you follow the calculation in your definition, you would take the total number of rooms at 11, divide it in half, come up with 5.5, and then round down to the next lowest number, 5, which is
Right.
what we are presenting the plan as.
Right, but what we're saying is, if we call that dining room a bedroom, because it has privacy and it doesn't have at least a 6-foot opening, it has a closet, it can be considered a bedroom. Now you've got 6. And so you can't do that. You can't, you have to have 5 bedrooms or less. And if this opening from the foyer into the dining room isn't at least a 6-foot wide opening, then there's enough privacy for that dining room to be used as a bedroom. What we're seeing is a lot of people call rooms studies, dining rooms, playrooms, and then they use them as bedrooms. And just by writing dining room on the plan doesn't prevent that room from being used as a bedroom.
But your regulations allow you to have a kitchen, a living room, and a dining room without them being considered bedrooms. It's right in your regulation.
No, that's not
So are
the
you
way-
saying it's up to you to decide which room is the dining room and which room is not the dining room?
It's up to us to decide how many rooms in the house meet the criteria that they can be bedrooms.
Okay,
Regardless of what people, right, we've seen buildings that have a large room with a full bath, shower, bathroom, and everything, and it says study on it.
right, and studies
That-
are not exempt.
Or they could say.
Under your regulation.
They could say dining room, if it was near the kitchen. That doesn't exempt it.
But it's right in your regulation.
Yeah, I think part of the confusion is, in the state codes, they have the rule regarding total number of rooms in the house and presumed bedrooms. That kind of comes from the state regulations.
I'm seeing it right in your regulations
Well,
that
I think it's been-
printed off the
It is in
website.
our
It is in our, but it came from the state. We hadn't actually enforced it until more recently, but we are now. And that's how they label they're looking just for total number of rooms, and that's why that language is there. Then we have more specific language in our regulation, and Judy may know more about this, that just describes what's necessary for it to be called, to do not be called a bedroom, basically. That's, our problem is we see houses with many, many amorphous rooms that could be used as bedrooms. So in those rules, it used to be a 5-foot arch. You needed to create a lack of privacy, so it wasn't a bedroom. We had actually increased that to 6-foot arch, and then there's the ceiling height and the egress and windows and all that. And that just, it is a rule that describes what's necessary to not call a room a bedroom. Because we're looking at it from a different direction, and that is, we see houses with dens and studies and multiple family rooms and sewing rooms, and ensuite bathrooms in them, so they could be used as bedrooms. So that's how we've kind of come to that. I think that's part of the confusion. Now, I don't have the actual regulation language in front of us, but Judy, correct me if
That's
that's.
it right there. I mean, this is difficult for me because I tend to agree with Stephanie. When we put that in there about the total number of rooms divided by 2, I knew that could work for us or against us, and in this case, I think it's working against us.
No, we
No, not
can't solve
really.
this 5.
The house has 5
This-
bedrooms.
If the dining room is
Including
used
the
as
one
a
in the
bedroom, it
basement.
would be 6.
But
So
if,
how is
but,
that?
or it says presumed number of rooms divided by 2.
Right.
And that gives us,
Case it would be 5.
right,
It's
which is
11
what they
divided by-
want.
And this house has 5, 4 upstairs and 1 in the basement.
No, one.
And then this would be in the pool house,
So
and then this would be
total
6.
11 rooms divided by 2
2
is
is
5,
5.5.
So if this dining room is a bedroom, that's
Go
6.
down, it's 5.
which is what they're requesting, 5.
Right, but this room could make it 6.
I don't know.
But that's being counted in the total number of rooms.
Right, but that's just, as I understand it, one criteria. What we do is we look at this room, it says dining room, but look at this room up in the front of the
Yeah.
house and say, does it
So
have?
we're gonna favor the higher number that we come up with. So you're saying, yeah, that could be.
So we look at this room and say, what makes it not a bedroom? Well, it has an arch. Now it's a 6-foot arch.
So what is the size of that cased opening, Stephanie? Can we make it a 6-foot cased opening?
I
You know,
didn't
I'm-
think it would be a big, probably,
I'm
architectural.
sure that we can put a 6-foot cased opening into that dining room and also into that lounge in the lower level. The lounge in the lower level actually has, it's
Sliding doors.
mostly below grade. It only has small windows.
Yeah, so that
So
would.
that can't
Yeah,
be a
so
bedroom.
you're right, that may.
You don't have to worry about that.
Yeah, so if need be, we can put a 6-foot cased opening into that first floor room. But when you take the time to come up with these regulations, and in fact, in the regulations, it says, please note that at the Board of Health meeting on August 15th, the board voted to also use as necessary the Title V regulations, which states where the total number of rooms for a single-family dwelling exceeds 8, the number of bedrooms presumed shall be calculated by dividing the total number of rooms by 2, then rounding down to the next lowest whole number. So it wasn't
that allows 5.
inadvertently put in your regulations. You met and discussed it and decided to include it in your regulations. So when does it apply?
It applies now
On
because
your-
that allows 5 bedrooms. And you have
Regardless
5
of-
bedrooms. It doesn't allow 6 bedrooms. And if the dining room is a bedroom, now you've got 6 and it's not allowed.
But your
can't count it
definition
twice.
doesn't say it only includes rooms that aren't bedrooms. It includes total number of rooms, regardless of how they're constructed. All I'm saying is, you have these regulations, and you need to enforce them
We are enforcing it.
consistently,
If you have 11 rooms,
which you
you're
do.
allowed 5 bedrooms. You have 5 bedrooms. If the dining room is considered a bedroom, you have 6 bedrooms, and it wouldn't be allowed.
Yeah. All right, let's, to further the conversation, I think there's 2 different ways we're looking at the bedroom situation in houses. That's what it amounts to. But I think Dr. Duncanson has his hand up for some input here.
Yeah, I was just going to indicate for the board that, as shown on the plan right now, the opening between the foyer and the dining room is approximately 48 inches. And it is not a cased opening. There is actually a barn door there. So that's just something else you may want to take into account, that it is not just a cased opening. It does have a barn door that could be closed off.
Okay,
So
thank you
Thank
for
you.
that.
it needs to
It needs to be an open, 6-foot
a
open.
6-foot opening.
Plus, let me just point out, this dining room has a closet.
Right.
I mean, it looks like a potential bedroom, if you just want to be objective.
Right, I mean, you've
All
got this
bedrooms have a closet, not all dining rooms have a closet.
There's a
No.
gigantic great room. You could put a dining room table in that great room. That would be your dining area. And then the dining room on this plan becomes a bedroom.
So, open 6-foot wide.
So if we submit revised floor plans with a 6-foot cased opening from the foyer to the dining room with the septic permit application, is that acceptable?
Yeah,
Okay.
Yes.
yes.
And the bedroom rules, it's really like two different criteria that we're looking at things, and we put it together. It may be confusing with what the information you're getting, so we'll have to review that and make sure we're getting out something that's easily understood.
Okay.
So I appreciate that we may have to do some work there. So any other comments or questions from the board? Okay. And then any comments from the public? Okay, and then can I get a motion to approve the variance with that one change?
I will make the motion that we approve the variance request with the stipulation that the dining room connection to the foyer is a 6-foot wide cased opening. And then there are also these other 4 conditions that Judy could.
Yeah, Judy,
I made the motion, still need a second, right?
yeah.
Second,
Carol seconds, and Judy can read the conditions, please.
There's 9 conditions. The applicant should restrict the property to a maximum of 5 bedrooms and record this restriction on the deed at the Barnstable County Registry of Deeds. The applicant shall submit a copy of the executed deed restriction to the Health Department. The applicant shall sign a covenant with the board agreeing to comply at such time as the town of Chatham, through its Board of Health and/or Board of Water and Sewer Commissioners, directs the connection of this property to the municipal sewer when it becomes available. This covenant and 5-bedroom deed restriction shall be recorded at the Barnstable County Registry of Deeds and submitted to the Board of Health. Throughout its life, the system shall be under an operation and maintenance agreement. The operation and maintenance agreement shall be for at least 1 year and may be with any mass certified operator of the appropriate grade that has received training by the company on the operation of the system. Effluent from the system shall be monitored at least twice per year for the first 2 years, preferably May and October. The effluent shall be field tested in accordance with Mass DEP standard conditions for secondary treatment units certified for general use, revised March 20th, 2015. Additional lab tests of the effluent for total nitrogen to meet the performance standard of 19 milligrams shall be collected and analyzed by a certified lab. Water meter readings are to be provided with the semi-annual reports. If any of the field tests or lab tests fail, follow-up tests shall be conducted by a certified lab and an evaluation made by the operator within 30 days. After the required 2-year testing, application can be made to the board or their agent for review and possible modification of the monitoring requirements. The applicant agrees to apply a minimum of 6 inches of compacted topsoil to all disturbed areas of the property. The engineer shall submit an engineered as-built plan, including as-built elevations with a written certification that the system has been installed in accordance with the approved plan. No alteration to the floor plan of the dwelling or the engineer's site plan will be allowed with further review by the Board of Health or its agent. This variance gets granted pursuant to the State Environmental Code Title V in the Town of Chatham subsurface sewage regulations and is valid for 1 year from the date of the Board of Health approval. A permit must be issued and work commenced during this 1-year period or the variance shall expire.
and you want to put in about the 6-foot cased opening.
Right, and that's in the motion, so that's the condition.
Okay, we have the motion and a second, and I think we can take a voice vote. All in favor, say aye.
Aye.
Anyone opposed? Okay, so that
thank you.
passes.
Thank you very much.
Thank you, and we'll work on making sure that language is clear and that it's kind of two different things,
Okay.
two different ways of
Yeah, I
looking
mean,
at the
it's
bedroom
good to
count.
know going in what your parameters are.
Absolutely,
So,
absolutely.
Okay, thank you.
Okay,
Who is she? She's been here before.
do you want to sit up here or stay there?
Ed, you want to come up? Ed? No? You good?
Okay.
Just,
All right, we have our third item is review the short-term rental regulation. So you all should have gotten a draft with a couple of minor changes made following the review by the attorney Attorney Costello at our last meeting, and they include some cleaning up of the legislative intent and authority language. We did add under occupant, definition of occupant, any individual of any age, so it's clear that it includes, children are included as occupants. And then the one other change was page 3, in terms of contacting the operator, that with able to respond to any emergency that arises during occupation within 1 hour of contact by the town's health division. It implies that it could be by phone. The previous language had said in person, which was difficult. So those are the 3 changes. Otherwise, it's the same and straightforward. And so I think that the way I see it is that this draft is the one that will be put out to the public for the public hearing that we're having in 2 weeks. Yeah. Dick.
Can I ask one question? I don't see in this document, apropos to the previous discussion, what will be considered a bedroom? What's the definition of a bedroom? Are we gonna get into arguments with people about how many bedrooms? I mean, my understanding was it was the number of bedrooms allowed by the septic system in that house.
Correct.
But it doesn't really say that, you know, and if somebody comes in and says, you know, my house has 6 bedrooms, and it's a 4-bedroom septic system, you know, it doesn't say how we determine what's the allowed number of bedrooms.
The number of bedrooms depends on the septic system design.
It doesn't say that in this document.
But it does say that the occupancy is determined by, I believe,
Yeah, it's on page 3, under occupancy requirements. This says, the maximum
As-
number
right,
of occupants in a short-term rental shall be 2 per bedroom, as defined by Board of Health regulations.
yeah.
Plus 2 additional occupants. So I think it states that the rule that's being used is the Board of Health counting of bedrooms, and that goes by septic. And so that
So as these registration requests come in, they'll be reviewed and compared with what we have on file as the allowed number of bedrooms for that house pertaining to their septic system.
Yes,
And if somebody requests a certificate for 5 bedrooms and they have a 4-bedroom septic system, we'll just disallow that application.
right. We would certainly have a discussion with them and visit the property if there's some discrepancy, for sure.
So that's part of the process of taking in and reviewing the application. That's part of the process of applying, is that the information on the application will be reviewed for accuracy and completeness by the Board of Health prior to issuing the registration. And for a house that's on public sewer, there will also be a reference point for that.
Yes, it will be the same, it'll be what they're approved by the sewer, or we would use the same definition, that's how we determine what their number is for their sewer connection.
Okay, so it all flows from the Board of Health.
Yes. Yep.
Ron, did you have a question?
Yeah, are we gonna go by what the septic system will hold according to our requirements? Or what if it's on the taxes, it says it's 3 bedrooms and we only have 2 bedrooms?
Yeah, so is the assessor's count of bedrooms versus the Board of Health count of bedrooms. And it's been pointed out that they're different, but we have explicitly said it's Board of Health regulation count
preeminent.
of the bedrooms. So I think initially, there may be some confusion, because people look at the assessment and they may see a different bedroom count. And that'll have to be dealt with over time.
Yes.
But also, I think part of this is going to be the public rollout of this and public information, and getting information out to everybody about this. And that's one of the points that probably will need to be, may need to be emphasized or pointed out at least. And then, at first, Judy will look at the Board of Health bedroom number. Inspections will be something that's ramped up at some time later on, and that's yet to be determined how all that's going to happen and when. But there's a statement in here that says if their application is approved, you know, it doesn't mean that everything is right in the house. We still have the right to inspect it. Anyway, that's, okay, other,
And then under penalties, you know, we say $200 a day. We don't really say that persistent penalties will lead to consideration of revocation of the certificate. Up higher, we say we can
Yes.
revoke the certificate, but we don't say under penalties that revocation of the certificate is a penalty that will be imposed for continued violations. You know, so, you know, I mean, people are gonna say, well, you say it's $200 a day, and we're paying you the $200.
But it does say the Board of Health may, in
May.
lieu of suspension or, in lieu of suspension or revocation, modify any rental certificate to impose additional conditions. I think they work together. I could check with town council to make sure that that language is.
This is standard
consistent.
wording. This is standard.
I think we
Pretty
just,
much, yeah.
I think we discussed that with the attorney,
Yeah.
He looked at this and he didn't seem to have any
and
concerns.
it's $200 per day, and the different legal benchmarks are per day, but we basically have the authority to, case by case, to decide when we're going to revoke
Suspend or revoke, right?
registration. We can do that, and.
Right.
So we'll just have that ability, and we can make it up as we go along. You know, if
Well-
somebody appears to be persistently in violation,
Yeah.
we call a meeting, and
Well, I wouldn't say make it up, but I think that there'll be a hearing,
Yeah.
and then everything will be presented. And we have the discretion to do what we want, but we'll be setting precedents, so we have to be careful of what we do.
Right.
And I said that early on, there's going to be a startup period. People don't know. They may legitimately, you know, have an argument for why they haven't done what they're supposed to do. And so I think it's good for us to have flexibility case by case early on, because at the beginning, there may be some people we don't want to come down hard on with as it's ramping up. But we have to be a little careful of precedent too, but we can, you know, put that in there. So I think the attorney, we kind of talked about it, and I think this is what we decided in my mind.
right, we'll have the best case if people are advertising more rooms than we're allowing on their certificate. And if we tell them to stop running that ad, and a month later they're still running that ad, then that would be sufficient to
There's
consider
all
revoking their certificate.
types of scenarios we could discover, and I think our overarching strategy will be to use the most minimum amount of coercion we can to get compliance from the public, who I believe in 99% of the time will understand what they need to change and will adjust accordingly. But if we have a problem, a repeat problem, a serious problem, or a backstop is the suspension or revocation of the permit.
Right.
I don't think we're gonna find ourselves having to do that, but we need to have it there in case we do.
Right, so I can write fines, tickets, and if we have to go from there to the next stage would be the hearings and the revocation or, possible revocation of a permit.
Just having the authority to do that should be enough to gain compliance.
And, yeah,
But
that's the way it works in my
revocation of
experience.
a registration came up, they'd be given notice, there'd be a hearing, they would come in, and it would be all presented.
And the town council will probably be here guiding us through the process. So,
Theoretically, we could start assessing fines in September of this year.
Separately.
If people are advertising more bedrooms than they're allowed.
where's the effectiveness date?
I don't believe that's true. I think the effective date is July 1, but that's for registration,
Okay.
the registration period. I don't
Well,
expect
that's
to
gonna
be.
create a problem if people are advertising.
Well, we won't
many
approve their,
bedrooms and
we won't,
taking deposits.
but we won't approve their application, so that's their risk if they do that. I mean, they're gonna apply to us, and then they have to hear that their application has been approved. So, they're doing that at their own risks.
Right, so the registration will begin July 1, 2023. They can begin to register. The first year where all the regulations are enforced will begin March 1st, 2024, and then be in effect that summer. So while we're taking registrations before that March 1, 2024 date, no, we're not going to enforce regulations because people may not have even registered yet. We don't really know, so it won't really start until that March 1. The regulation enforcement won't start till March 1 of 2024.
But
As
all
I
the-
understand it.
But all the rental agencies in town will be very well aware of what's coming and when it's gonna come. And,
Hope so.
so we can assume that they will be proactively adjusting where they need to, contracts for various occupancy, knowing what is gonna be in effect the following year.
Yeah, I think you're right, and I think what you said, if a renter reads the affidavit, everything, and then signs the bottom, 98% of people will then follow those rules, I hope, I think.
Yep.
But brings up another point. So today, we're just gonna approve this as the draft for the public hearing. Then after that, we'll have another discussion, but I think then there's a discussion about the rollout of this, the public relations. One of the things that came out in the working group was an emphasis that there should be a public relations, an information strategy to the public, the residents, covering all these things that you're bringing up, Dick, so it's clear. And that may be multiple things. I mean, there'll be a press release, there may be some other things, other documents, something in the Chronicle and it'll be a work in progress,
Right, that's the Chronicle is the way to do it initially. If we have a meeting on April 3rd, and at that meeting or the following meeting, we approve it, then immediately there needs to be a big
A display ad.
Display
I would say
in the
we buy
Chronicle
a
saying-
quarter-page ad
in
and
this
Yeah,
day
we
forward.
will print the entire regulation in the Chronicle. That's what we do. Unless it's a minor change, we do print the entire regulation, and I'm sure it will be well covered by the Chronicle as well, in their, regular pages.
I mean, printed in the advertisement section
It
at
will
the
be
back,
printed in the
legal ads.
The legal ads, yep, which I know people don't always
Yeah,
read, but.
people don't read.
But if people are interested, then they'll see it. And again, I'm pretty sure that the Chronicle will cover this, and have information
a
available.
featured article.
And it's
about it.
also, it's on our website now, the draft version. It's available at the counter upstairs if anybody wants a hard copy. So anybody who's interested can definitely get copies of it. So,
Have we ever, in this sort of situation, has one ever contacted the Chronicle to have a sit-down, say, to really go over things and put things out there that they might put in separate?
you mean,
Yes,
yeah,
Dr. Duncanson, yeah?
Yeah,
yeah.
So that you're not out of line doing that, and then it would be up to the paper to do what they wanted to do. But to me, that would be a good way to get a lot of information into,
There's
Ramp up
99% likelihood Tim Wood will be watching the April 3rd meeting.
right, but it might be helpful for Judy and some other people to sit down with him and have a Q&A and, or bring up some things or point out some things that might be confusing, go that way. So,
we'd be happy to do that
Yeah,
with Tim,
so-
and he knows he can come in and talk to us.
Right.
He's in and out.
so today, I think probably what we might do is just take a quick vote that this draft that Judy has sent out is the draft that we will put to the public for the public hearing.
do we call that the final draft then, or just the draft, or?
No, because I think we
I would
might,
call it the public hearing draft.
We vote.
we might have a discussion after the hearing, and theoretically, you could add something or clarify something with another draft.
Right.
Okay.
Okay,
I'll make a motion that this be the public hearing draft
Correct.
for the April 3rd public hearing meeting.
okay, and a second?
And
All right, any public comment? Yeah, public comment, that you seconded, right? Yeah, public comment?
I don't see any.
Okay. All right, maybe we can take a voice vote then. All in favor of this being the draft for the public hearing? Say aye.
Aye.
Any opposed? Okay, then that will be how we proceed, and then there'll be the public hearing. Then afterwards, we'll have a discussion, hopefully brief, about what was brought up in terms of the final regulation, and then there'll be a vote on that at some point.
So we can, based upon what happens at the public hearing, it's the board's prerogative of whether to then hold an initial vote of adoption, or whether to hold it for additional discussion or an additional revisions after that.
Yeah, in the past, we've had public hearings and no one's come, but I
Right.
have a feeling this one will be a little bit more controversial, so we can decide after you close, you have the hearing, you open it, you have the hearing, then you close it, and then you don't accept any more comments, and then the board can decide whether to vote or to have another hearing or discussion.
Another review, okay.
Yep. And then, something that's been on I've thought about is, this is sort of contingent on an additional person in the Department of Health to help administer this. That's pretty important. And I've been sort of following, I'm not an expert here by a long shot, following through the funding process and whatnot. Dr. Duncanson's been working on that in his department. And so the town meeting is May 6th, I believe. That's when we'll know 100% that this position has been created. As I understand it, the position is in the operating budget. That's that big $39 million thing. And from what I know, that pretty much passes. It's very unusual, or maybe unheard of, that somebody would single out one item for a vote, which would probably, I think, would fail anyway. But, so it raises the question in my mind, does it make a difference to us whether we vote for the final registration before or after the town meeting? And I'd ask Dr. Duncanson what he, because there's not much harm in delaying till the town meeting. On the other hand, it's probably pretty clear what's going to happen.
Yeah, I would say at this point, I'm pretty optimistic the position is going to be funded. Obviously, it's up to the board. If you have any concern about that, you could always wait till after town meeting to vote the final version. But I mean, the position has gone through the Board of Selectmen. It has gone through the Finance Committee and be supported.
Okay.
And you're correct that generally town meeting doesn't make substantial changes or whatever to the town's operating budget. You know, it's a,
Yeah, and
it's a big $30+ million number, and very frequently, you know, there's no discussion about it per se, so. But, you know, you never know what could happen at town meeting.
Okay.
But if they didn't approve that position, I think we would still pass, we wouldn't I don't think we'd modify this, we would just have more difficulty enforcing it. But my question is, if somebody comes to the open meeting on April 3rd and makes a comment, and we say, oh, that's a good comment, we're gonna add another line to this, do we then have to have another public meeting for the revision of the draft?
Depends whether it's.
No, you
No.
don't, you don't have to.
Okay.
No, so you'd have the public hearing on the 3rd. The board would receive whatever public comments, and I assume you're also willing to accept written comments. And when we post the notice of the meeting, we will indicate that, you know, written comments have to be submitted by the 3rd as well. And depending on what you get, the board, you know, it's really up to the board as to whether or not, you know, if you make substantive changes to the draft, you may want to have another public hearing. But if, you know, if all the changes are relatively minor and I'll say non-controversial in nature, you don't necessarily have to have another public hearing.
Good.
It really depends on, you know, is there anything that you think is substantial enough to warrant another public hearing?
So if it's a clarifying addition, we probably would.
It's a judgment call.
And,
Right, it's a judgment call in many respects, yes.
I would just say, Dick, if we didn't get the extra person, I would ask Judy, who is going to be.
No, we would have to,
part of it
we would have to have a
administrate.
serious.
I would just have a
discussion
discussion about how that's going to work. So, but we'll leave that to later, and hopefully that won't be an issue.
Right.
But I don't know how that would change the regulation. It's how we enforce the regulation might change. But we don't say here, an employee hired by the town is gonna.
No.
But if,
enforce
No,
it.
but
it's theoretically possible, we could conclude that we wouldn't be able to effectively and professionally implement it without the funding, in which case we could.
It's a very large administrative task that.
Right.
Even without the inspectional part of it, and the
So I
enforcement.
think we
But
were,
I personally would not want to just not do this because the town meeting refused to pay somebody.
Well,
I
hopefully
mean,
that's.
and that would be a discussion that we
That's
would
what
have
we
to
want,
have
a discussion we
internally
want.
and then
That-
with you.
at that time, yes.
But I would say, I think this is a new regulation, and as we roll it out, and as comments been made by other people, I think it's important that we roll this out and we enforce it, and it goes in effect, and we have it work well right from the get-go in terms of the rollout. That's important to make sure the whole thing is is accepted. So that's in there as well.
Okay.
Okay, so I think we've got that, we've got our public hearing, that's all set, all the legal notifications and all.
Yep.
And so I think we can move on to the next item, which is item 4, John McGrath, 32 Mill Hill Road. And I think Judy was trying to get some feedback from the state.
And I have not had any luck, but Bob, he's reached out as well, so I don't know if you've heard anything yet, Bob.
As a matter of fact, I just got off the phone while you guys were talking about the short-term rental regulation. So here's the latest update. I did reach out to Mass DEP, to the regional director for the Southeast region, and I just got off the phone with the solid waste section chief, who provided me an update on where they're at. Part of the delay, if you will, or the lack of information just stemmed from the fact that DEP has had a number of personnel turnovers recently, and, you know, this one just kind of got delayed. So anyway, it is now, the section chief is now the one leading this particular enforcement action, if you will. He has completed his review of the case, and the next step is to take it to an enforcement approval board. And that will happen in the next week or so. They generally meet every Thursday. They were not going to be meeting until till mid-April, but they are scheduling an interim meeting because he has this one and a couple of other enforcement actions to take to that approval board. So hopefully in the next couple of weeks, we would receive notification of how that went. And the next step, depending on how it goes, would be DEP would issue a notice of non-compliance. He and I talked, he's going to keep us in the loop, over the next week to 2 weeks as this moves forward to the next step. So there is movement on the part of DEP, and frankly, he apologized that it was taking longer than normal. But as I said, they've had some personnel changes, and it just has delayed things. So that's the latest on the DEP side. We did send the Conservation Commission letter. That was received by Mr. McGrath. He did reach out to the conservation agent last week, and they were going to have a conversation about that primarily as it relates to the Barnhill Road shanty situation. So that is also in the works. So that is the kind of latest, hot off the presses information on the McGrath situation.
Okay, well, that sounds like
Progress.
progress, more than we might have hoped. Can you are you comfortable putting that in just a little memo that goes out to all of us so we have it in our record of where we are? Okay.
Yes, I will be sending out something to other town staff as well, the police chief and others that have been involved in this, and I will copy the board when I send that out.
Perfect.
Great.
Thank you.
Okay, public comments on 32 Mill Hill Road? All right, I think that's good. Any other comments from the board? Otherwise, we can move on to 5, update COVID-19, and Dr. Duncanson.
Nothing really new and earth-shattering with regard to COVID-19. As I've said in previous meetings, it is still out there, and I think you heard that tonight with Attorney Riley and the fact that his partner has it and has come down with it. It is still out there. CDC remains at the low community level for Barnstable County. Hospitalizations, on Cape Cod, between Cape Cod Hospital and Falmouth are, running around 10 to 12, which is pretty much what they've been for a significant number of months now. I'm sure you all heard, because I sent out the information, the state of Massachusetts will be stepping back from their public health emergency declaration on May 11th, at the same time that we step back from that declaration on a national stage as well. So, I think we are getting closer to COVID being treated more or less like the early flu, although the World Health Organization has not yet downgraded it from a pandemic to an endemic. We'll see if that comes in the next couple of months or so. And as I've reported before, we do now have a home test kit that can make a distinction between flu and COVID-19, because the two of them, they share a lot of symptoms together. And so, for many people, it's important to be able to distinguish between the two. So with that, happy to answer any questions.
Does this mean that Judy will stop having to read this multi-paragraph statement for all of our meetings?
We're waiting for the state to
Lift.
lift that part.
Well, to me, the question is, May 11th, do we then stop having the ability to have hybrid meetings? Or
No, that is still somewhat uncertain. At the state legislative level, the House has passed one version regarding the open meeting law. The Senate has passed a different version. It is currently in conference committee. One of the two, and I don't remember which one was which, but one of them extended the idea of hybrid meetings through December of this year. The other one was extending hybrid meetings through the end of 2024. So like I say, it's in conference committee. Last I heard that they had not come out with one that could be supported by both, organizations. They do have until March 31st to make that decision. So I would expect either sometime this week or next week, we will get something definitive from the state regarding hybrid meetings and whatnot. I think, from everything I've seen throughout the Commonwealth, there's a lot of interest in maintaining the ability for communities to hold, kind of hybrid meetings like yours, because, from the public's point of view, it definitely provides the opportunity for a lot more public input, because people don't have to physically attend meetings.
Yep.
If they're away or they're away for the, the winter in Florida or whatever. So there's a lot of interest in trying to figure out the best way to maintain that. So
And then-
more to come on that, I'm sure.
And then this part that Judy reads, that goes along with having a hybrid meeting, is that correct?
Yes.
Yeah, okay.
Part of that has also the ability of members to be able to vote if they're not in the room as well.
Right.
So that might go
Yeah.
away.
Yeah.
I've been hearing that there's some disagreement within the CDC about the need for elderly and immunocompromised people to get another booster this spring. That most people in that age group that are at high risk are now 6 months since their last booster, and there are some who think that it's very important to continue to boost that group of people, and others who say, let's wait a year. And I don't know if you've had any further information about that.
No, there's been no updated guidance come out, and there are two different schools of thought. However, I think all you have to look at is the recent incident in Yarmouth at the assisted living facility there, where they had more deaths this year than they had in the first 2 years of the pandemic. That they are, that is the more susceptible population, if you will. So I wouldn't be surprised if there's, erring on the side of caution, and the recommendation does come out for, certain groups of more sensitive individuals receiving vaccination or booster vaccinations on a more timely basis than maybe the general population. But there'll be more to come on that, I'm sure.
Okay.
Okay, thank you, Dr. Duncanson. All right, if there's nothing else, we can go on to the minutes of March 6th.
I'll make a motion, we approve.
I had a couple of corrections.
Okay,
On page 5, at the end of 1, it's talking about the dates, and at the end of the sentence, it should read through February 28, 2024, the first registration deadline for the rental season of March 2024,
gotcha.
not 2025.
Yeah, that's important. Good
And
catch.
what was the other? Okay, maybe let me just look, I thought there was per day, not committed. Oh, it was page 6, the second paragraph, it starts off with parking. Attorney Costello agreed that a police officer could be designated as enforcement agent in regulation. I don't think he said should be, I think he said it was could. It's
Did we do that?
sort of open.
Did we do that in our final draft, Judy?
No.
I didn't change it because.
I think it's open.
I didn't change it because I think we agreed that the wording in there was sufficient, that the police do have the right to enforce parking anyway, so.
And that's the only,
Where was that correction?
Page 6, second paragraph, which begins with the word parking.
Oh, okay.
I just saw a word here.
In both the second and the third line.
Yep.
There's also on page 6.
So it's supposed to be could, okay, so it's twice. Yep, John?
Page 6, first paragraph, Attorney Costello, second line, off to the right, very minor, and careful not to set a precedent versus precedents. Very minor detail.
Got it?
Okay.
We always have a problem with that word.
All right, can I get a motion to approve the minutes?
I'll make a motion that we approve the draft minutes of March 6th as amended.
A second.
Ron, second. Take a voice vote. All in favor, say aye.
Aye.
Any opposed, say no. Okay, those minutes are approved. And if nothing else, then we can probably adjourn the meeting.
Move to adjourn?
I'll second.
All right, and take a voice vote. All in favor of approving the meeting, say aye.
Aye.
Aye. Opposed, say no. Okay. We are adjourned.
Thank you.
All right.